Zulu royal family. Within that description of the Zulu royal family is the ruling family. So what we tell you there is that the institution of the Zulu royal family consists of 13 houses, royal houses. There's 13 royal houses. There's 12 that are mentioned there. Then there's the 13th where the king, the late king, was coming from. So there's 13 royal houses, and each one of those royal houses has its own head. Amakana is in, of course, amaZulu. Of course, amaZulu consists of those and nothing else, and everything else is below that. So we detail there, and Isim, the late king, was Inkosi Amakosi as in King of Kings, because he himself, in his own right, Uinkosi. So because there's 13 of them, to distinguish him as Isim, he had to be above the other kings. So he was Inkosi Amakosi on that basis. But it's still on the basis of the 13 royal houses. We go on there. So that's what constitutes the Zulu kingdom and the nation. Then we describe how they operate. So that's the organogram, that's the structure, and that's how the Zulu royal family operates. Then within those 13 royal houses, the ruling family in Lugapusha, which is the late king's father, King Misuzulu. That is the ruling family. From the lineage, in determining lineage of the kings, the ruling family in Lugapusha, which is the late king's father. And Amakanda is linked to all those heads of those royal houses. It's not in dispute, determining that the next heir would come from Lugapusha, which is the late king's father's house, royal house. Then in volume 5, at page 873, is a statement. It's actually an affidavit of one of the heads of the royal houses. Umntwana omkhulu uMasu kaZulu. 872, volume 5. There's a statement there. What it does there, because India is one of the 12, is one of the 13, and he's the head. He describes in great detail the architecture of the broader Zulu royal family, as I've indicated. And in paragraph 6 of his letter, of his affidavit, he talks about the structure and the important rituals that are carried out by the Zulu royal family as a whole. All those rituals that are listed in paragraph 6. At paragraph 9, he tells us, he says, the royal family always determines the royal house from which a king will emerge. So Amakanda, 13 of them, 12 of them, 13 of them determine where the next king, from which royal house the next king will come from. So he goes into great detail. Then in paragraph 13, it gives his view of the meeting of the 14th. Well, before paragraph 13 and paragraph 11, he expresses regret at the role that the late Ushenge played in the ceremony, and you can read it, what his regret is there. And it's very simple. Undunankulu, the late Nkosi Ushenge, is from the Buthelezi clan. He's not Zulu. He's not Zulu. As a distant relative of the Zulu royal family.
But we have to accept that he was referred to as Prince Mangosuthu Buthelezi.
Yes,
for the reason.
He's a prince because he's a distant
so
relative.
you can't just wish him away. Can you wish him away?
No, Deputy President, nobody's wishing Ushenge away.
Yes.
I'm explaining his context, and we know how he's related. Umshana in the in Ndlunkulu.
Yes. Yes.
In other words, he is a nephew to the royal family because it's through the late Princess Magogo, his mother, who was a princess.
Okay.
the organogram is important to understand it because that is custom. That is custom. It can't be wished away, it can't be changed, however anybody may feel about it. So what happens at the end of the day is that when a member, a senior member, a head of one of the royal houses expresses the regrets that he expresses at 11, that is significant because it is a head of another clan engaging in the manner that was engaged in the affairs of the Zulu royal family. So that's at paragraph 11. At paragraph 13, he gives his view of the meeting of the 14th, about what that meeting was about. Then at paragraph 14, he describes the rituals again that are performed. All of them. Those are all the rituals. And those rituals are mandatory. They are custom. They have to be carried out, including the cleansing of the cleansing ceremony. All of those have to be performed. Then at paragraph 15, he goes further. He describes the rituals that were performed by the Zulu royal family, but in which the late Prince Buthelezi was not present because they didn't consent. Despite his role and status, he can only go so far. For example, he wouldn't go that far. And that is no. So that is the custom.
Mr. Simelane, I asked Mr. Masuko yesterday that if these rituals were not followed, did that invalidate the choice of the potential king or queen? Because he seems to indicate it can also be a queen. And he said his answer was no, it wouldn't invalidate.
No, some of the rituals are rituals that are performed by the family as part of many events. For if there's a funeral, there's a cleansing ceremony, it has to happen. But here's what is important to your point, Justice Nichols, about whether it invalidates. It talks to the status of the meeting of the 14th and what it means. That was a cleansing ceremony. In Zulu custom, in Zulu culture, when there is a death as a custom mandatory, Zulu people observe the mourning period, Uzila, for a certain period of time, during which period nothing gets done because Uzili. Nothing gets done. The normal day-to-day habits and activities that are performed are all put on hold. You don't even milk a cow during that period. The meeting of the 14th breached one of the most sacred customs of the Zulu nation, which is the mourning period. It took place, that meeting of the 14th was called not just on the day of the cleansing ceremony, it was called to discuss and nominate somebody as a successor during the mourning period. The custom was
sorry, Mr. Simelane, I'm worried about time, but what about the meeting of the 5th of May, what about the meeting of the 5th of May in which Prince Monisi, President Monisi attended? Because if you say nothing should have been done during the mourning period, then that would equally apply to the meeting that was held on the 5th of May.
For the point
you can't say to others, don't hold the meeting during the mourning period, while at the same time you are holding meetings during the same period. It's double standard, Mr.
No, there's no double standards. For purposes of the point I'm making...
No.
Deputy President, can I make the point?
Yes.
The point is this.
Yes.
I've described, and the affidavit of Mtanumazu describes the organogram, the culture, the 12 royal houses. Indlu Ebusayo, which is Indlu Gabusha, which is the late king's father's house, which is the ruling family. The definition of the Act says it is that family that sits and identifies. So in Indlu Gabusha, who do you have there? In the review application, we have 4 main areas: Prince Mbonisi, Prince Vudindlela, Prince Matsubesizo, and Prince Umpolisi. And there's Princess Ulimbu. Those 5, the siblings of the late king. So the siblings of Upusha, the late Isilo Upebuzu. Those are his children.
Sorry, did you include Princess Ndlovu? Did you include her?
Yes, Princess Ndlovu, yes. She's Ndlovu because she got married. Those, and President Police is here. He's the most senior person in this room. He's here in this room. He's the most senior person to all of them, including.
Sorry. Mr. Smilan, I think that you are going to answer my question. My question
Yes.
was related to what happens during the mourning period and whether meetings can be held during the mourning period.
No, they can meet. The meeting, what the case is about.
Yes.
The meeting, the family that decides and identifies who the successor is, did not get an opportunity to do that because that meeting did not happen.
The meeting of the 5th of May.
No, I'm not talking about the meeting of the 5th. I'm getting to the meeting of the 5th. The complaint in the case, Deputy President, is that the people that are the ruling family in the Ugapush, that ought to have said, exercising their customary right to identify the successor, did not have an opportunity to do that because of the events that took place before. The meeting of the 5th, the meeting of the 14th, those meetings are irrelevant for that point because that meeting did not take place. The other meetings did take place, yes, but those meetings, the meeting of the 14th, the minute says so. It was a nomination and the name was given there and it was supported there. But the people in that meeting are not the Indlugapusha that decide who takes the throne to succeed the late king. It didn't happen. The elders.
So we must regard both the meeting of the 5th of May and the meeting of the 14th of May because they were during the mourning period.
You don't disregard them. Look at the algorithm and the statement of Prince Masu and Prince Mbonisi in his affidavit. They describe processes leading to identification. So custom, where you get to identify, follows certain procedures. It's not an event that it just happens like this. So there are meetings where the broader royal family meets and discusses. In fact, I want to refer you, we put in
Mr. Smilane.
Yes.
What is your submission? Is it your submission that the meeting that was properly constituted is the meeting of the 5th of May?
No, the meeting of the 5th of May was not properly constituted for purposes of identifying the successor.
But Prince Muniz was there, your client.
Prince, that was not a meeting to identify.
No, go to page 730, 739 of the record. Go to 739 of the record.
We will go to the, what I'm describing, Deputy President, which you must understand, and you've got to understand this, to understand what all these meetings were about, leading to what the complaint is about. The broader Zulu royal family, as I've described, which is Amakhan, all 13 royal houses, have a role to play. They get consulted because of their lineage, which is undisputed. They've got to be consulted. Once there's a decision on the ruling house, which is the Ugapush, the other royal houses, from principle of which you know, Uwebuza, they take a back seat. Uwebuza means that they take a back seat. And the ruling house takes charge, which is the house of the late King Misuzulu.
Yeah.
That's the ruling house in Ugapush. And if Amakanda have decided that it is that house where the next king will come from. It is the members of that house only that decide who amongst the people there qualifies to be the king, and they identify the person. The other royal houses, from the principle of weapons, take a back seat. They can't go and impose themselves.
All right, so your short answer to my question is that that meeting of the 5th of May was unlawful.
It was not unlawful.
It was
not an identification meeting. It was a meeting of members. Call it a consultative meeting.
Do you want to read? It's written in isiZulu. The minutes are in isiZulu. 739 of the record.
Yes.
Okay. You just make things easier for you.
So I'll sum it. I read it. It says, that's what it should say. For that purpose, it is unlawful because it's not an identifying meeting.
Okay, you have answered me.
Yes, but for purposes of contributing, Deputy President, to the identification meeting that was to take place, it's of value because it's consultative, because it indicates the views of other broader family members of the Zulu family. But the immediate relatives, who are then responsible for identifying, if they had an opportunity to meet, as the custom dictates, they would have taken into account the fact that there are these other views. And when they consider all amaZulu, all of them, they will take those different views as important factors in identifying which one specifically amongst them to identify. It just didn't get to that particular level because things took a particular event. So in essence, the meeting of the 14th of May, which the President regarded as the important meeting, my other friend, Mr. Masuku, dealt with it yesterday, its composition and where people came from that attended that meeting. That meeting was not an identification meeting. For purposes of what the case is about, the complaint is about that the applicants in the review application did not get a chance to meet and exercise their rights, exercise their custom to identify an end. For that purpose, the meeting of the 14th does not assist this particular court and was unlawful for that purpose.
Well, I think that we've covered that point. Mr.
Yes,
Masuku covered it yesterday.
So, I wanted to... Oh, there's an issue about custom, the importance of custom and great wife. Just to remind the court that the funeral and all the ceremonies that related to the funeral of the late king took place at Kwaketomtala in Paris. You know what? That is where the first wife resides, Queen Winifred Dlamini, the main wife. And everything took place there in recognition of the fact that she's the first wife and the most senior wife for that reason. It did not take place for Kagela, where Queen Mantoni resided. She was still alive when God said. It didn't take place there. So the ruling family, in giving that clear distinction, without giving an indication who's great and who's not great, because there is no great wife. There is no great wife. The queens are in accordance with who came first in the womb. It's who came first in the womb. So it took place, all the ceremonies took place at Kwaketomtala, simply because that's where Queen Winifred Dlamini resided. And there was no complaint from the late Queen, Her Majesty. There was no complaint, because she understood perfectly that ranking system. So when you look at the definition, who the immediate relatives of the ruling family is Kwapeguzu, late Peguzu. That's the rule in Lugabush. That's in Lugabush. So the siblings, Prince Monisi describes it in his founding affidavit. His siblings, the late king's siblings that I've mentioned, Prince Mbonisi, Prince Vulindlela, Prince Matulesizo, Prince Mtolisi, those are the ones who sit and determine who the next heir is, taking into account all the other views. They didn't have an opportunity. As a family, remember, Deputy President, the late king, like a head of every household. The fact that his king is different, but first and foremost, he's the head of his own family. Himself, his wife, his children, like everybody else. And that is his family. So those customs that family has to perform, rituals, have to be observed just as much as the other extended customs of the whole Zulu nation. So the applicants and the case being made is that in our own family, Prince Mbonisi being the most elder, now that the king has since been deceased, could not lead that family in the manner that custom dictates, for the sole reason, and no other, for the sole reason that there were other participants who got themselves involved in those processes, and things turned out the way that they turned out. But by Zulu custom strictly, everybody should have observed the leadership in that house, in that family, in the same way that it happens in every other clan. Is that the first order obviously be upheld, and that order 2 be dismissed because it stands on the first order and naturally cost of 3 council Deputy President.
Thank you.
And for that purpose, Deputy President, the point would be that what should happen then, the matter would be referred to the appropriate place, which is the Zulu royal family, to do what they ordinarily would have done, but what turned out to be.
Okay.
As the court pleases.
Thank you, Mr. Sula. Yes, Mr. Thompson.
Maybe ask if we can do a bit of musical chairs.
Yeah.
So that our team can sort of report with experience.
There's no one to take them. Silence in court. It's unfortunate. Yeah, you see, it's just... Yes, Mr. Thompson.
Thank you, Deputy President.
Your 20 minutes starts now.
Deputy President, Justices of the Court, we've had the benefit over the last day and a half of listening to the exchanges that have taken place and the arguments presented. Like the proverbial curate's egg, they have been a good experience in part and a bad experience in part. Let me start with the bad part. It pertains to 5 documents that were relied on by my learned friend called Prince Misuzulu yesterday in his argument, all of which we say were inadmissible, prejudicial to Prince Simakade, and should never have formed part of the record. Difficult as it is to do, we would ask this court to think away all of these submissions that were made on the basis of those 5 documents. we applied in the High Court for the striking out of those documents, and unfortunately the application was never dealt with in Mr. Justice Davis's judgment, and hence the reliance by my learned friend. In fairness to my learned friend, I should say he wasn't part of the proceedings before the High Court, so he may not have been entirely aware of what had taken place there. But let me deal with the first one. That is the unsigned affidavit of the late Mr. Buthelezi. It is an unsigned typed document emerging from a law firm's typist. There is no affidavit by a typist or an attorney to suggest that it is a fair representation of the instructions that were given by Mr. Buthelezi. There is no evidence to suggest that Mr. Buthelezi approved of the draft. Prince Misuzulu patently cannot confirm Mr. Butelezi's evidence. He is half of his age. He's never held the position of traditional Prime Minister. There's no evidence to suggest that he used to accompany Mr. Buthelezi, and there's no reason to suggest that he would have been at every meeting and so on that Mr. Buthelezi was at. So the confirmation, we say, is not worth the paper that it is written. As we heard from my learned friend, from Mr. Mbonisi, the evidence on record is the fact that Mr. Buthelezi refused to sign that affidavit and remained so unwilling until his death because certain demands, unspecified demands, were not met. Even if it is accorded, even if it were to be accorded contrary to my submissions, the status of hearsay evidence is only admissible in those circumstances if the person who actually gave the evidence and upon whose credibility evidence actually comes and gets the evidence. Obviously, the late Mr. Buthelezi cannot do that. So we ask for that to be ignored in the court's adjudication entirely. The remaining four documents all form part of a bomb drop of documents that I referred to earlier this morning that took place after the close of pleadings, laid down by the court. The court laid down a timetable. Laid down one timetable. Prince Misuzulu came and applied for postponement 3 days before the hearing. It upset that timetable. A new timetable was laid down. The party complied with the timetable, filed replying affidavits. And after that came this veritable bomb drop of documents in excess of 800 pages, much of it related to a flurry of other litigation that had gone on, some of it in the form of vetting argument in relation to the three applications of KwaZulu-Natal. Now, I won't take the court through it, but the affidavit that deals with that and explains our objection begins at volume 24, page 4737. And the most important part is from paragraph 7 to paragraphs 11. For purposes of time, though, I'm not going to take the court through all of it. It basically tells us in more detail the tale that I just told about the impermissible late filing of all of these documents. And part of that bomb drop includes the signed affidavit of Mr. Buthelezi that was relied on by my learned friend. That is the document that appears at volume 10, page 1895. If I can ask the court to go there.
So what page at volume 10?
It's page 1895.
Okay.
And it is volume 10. Now, my learned friend referred to this as Chief Butelezi's answering affidavit in Prince Mbonizi's interim intellect application. Now, the problem with that is it isn't. It isn't the one that we've all been talking about as Prince Mbonizi's interim intellect application. If one looks at the top of page 1895, one will see it says in the High Court of South Africa, Gauteng Division in Pretoria. Not from the Pietermaritzburg proceedings. This is another application that was brought by Prince Mbonizi, which, just like Prince Mbonizi's application in KwaZulu-Natal, and Prince Makale has nothing to do with it. We weren't part of that application. We've never had an opportunity to respond to Mr. Buthelez's affidavit. And it's highly prejudicial that it's allowed in. It's got the further difficulty that our law does not permit evidence from one case to be uplifted and deposited into another case. It becomes hearsay evidence in that process, even if it was made under oath. So again, all the submissions on the basis of the signed affidavit of Mr. Buthelezi, we would ask the court to ignore. The final two documents are the affidavits of the purported experts, Professor Ngubani. And again, I'm not going to take it all there, but just to give the references, his affidavit is at volume 11, pages 2060 to 2099, and Mapalala, that's at volume 12, pages 2439 to 2467. And apart from the fact that they were part of the bomb drop there, we haven't had the opportunity to answer to those. There are further reasons why we say they're inadmissible, which relate into alleged bias and lack of expertise. And that is explained in the supplementary replying affidavit of Prince Makadi, paragraphs 13 to 14.6.2 at volume 24, pages 4744 and following. What then is the good part of the curate's egg? What we say is the good part of the curate's egg is if one sits back for a moment and thinks about the exchanges that have taken place in court, there can be no question that there is a crying need for an investigative committee, as envisaged in Section 84, to investigate the breaches of custom that have been debated in the court. And that is the position today, as much as it was the position at the time that the President was looking at the issue as far as the exercise of his powers were concerned in terms of Section 8. If I can then move on to another topic, which is the submission that the President was indeed compelled to act in terms of Section 8.4. We say that insofar as the High Court found that the President's recognition decision stood to be set aside as unconstitutional and unlawful, it is unassailable. As the High Court correctly held, the President was compelled on the clear peremptory wording of Section 8.4 to activate its provisions. To suggest that Princess Tembi's 40-page document did not constitute evidence or an allegation that identification of Prince Misuzulu was not done in terms of customary law and customs is simply unsustainable. The risk, with the greatest of respect, is that if this court were to hold that that document does not constitute evidence or an allegation as envisaged in Section 8.4, what disputant is ever going to cross that hurdle? Who is ever going to be able to come up with as comprehensive a document as Princess Tembi has come up with in this case? And I would respectfully, safely predict that there are going to be very few people who can muster a document of that nature to make clear their evidence and allegations. There has been a suggestion that there was a failure to identify customs and to identify their breaches in relation to the identification of Prince Misuzulu. We say that if one looks carefully at the documentation, that submission is entirely unsustainable. And unfortunately, I'm going to have to go through the painful process of working through that document to illustrate that. So if I can ask the court to go to volume 13, page 2471. And there we start with her introduction. She says, this document serves to lodge the above dispute by the quintessential section of the Zulu royal family, who are of the firm view that all processes leading and relating to the nomination and or pending recognition and nomination is perfectly good enough for identification. They're interchangeable. of His Royal Highness Prince Misuzulu, Heron Prince Misuzulu, as the King of the Zulu nation, were in violation of the Constitution, customary and statutory law, and therefore of no force or effect. And the point to bear in mind is that what follows, the entire document, the entire 40-page document, is designed to say, here are the customs, here are the laws, and here are the breaches that show that you got the wrong guy at the meeting on the 14th. If we look at just below the paragraph I've just read to you, the heading is Legislative Framework and Disputes. Now, what follows there is a detailed constitutional, legislative, and customary law framework. And this demonstrates that the submission is seriously advanced, by no means frivolous, bona fide, and setting up the foundation for a complaint of non-compliance with customary law in the identification process. If we go to page 2480, which follows that setting out of the legal framework, she confirms this. She says the principles extractable from the above case will be applied after dealing with the issue of Zulu laws of hereditary succession. At this point, and immediately before dealing with the issue of Zulu laws and customary succession, it is instructed to record, and then she refers to Alex Court, the Constitutional Court confirmed the equal status of customary law, that it must now be seen as an integral part of our law. Further held that on all law, it depends for its ultimate force and validity on the Constitution, and so on. Then it says, in the heading hereditary succession, both national and provincial legislation recognize two types of leadership positions so far as traditional leadership is concerned. And then at page 2483, the evidence is given at paragraph 1 that the nomination and appointment of the late Queen contravened customary law. And this is important. Yes, it is so that the Queen never got to fulfill the position that it was suggested she should fill. But her being nominated by the King and her in turn nominating Prince Misuzulu formed a crucial part of the sequence of events that resulted in the wrong identification of Prince Misuzulu. So it was important that they explored that part of custom and why there wasn't compliance. Then at paragraph 5 of that page and on page 2484 at paragraph 8, she gives her evidence that in terms of custom, the heir has to be a direct descendant of the king through a direct line of descent. As we were reading this document, it was verified who it's coming from a very senior, experienced member of the royal family. So these aren't just allegations. Our law recognizes that somebody in that sort of position is entitled to give testimony that's admissible about the content of customary law. So paragraph 5 and on page 2484, paragraph 8, she gives her evidence that in terms of custom, the heir has to be a direct descendant of the king through a direct line of descent. And then at pages 2486 to 2487, she sets out her evidence pertaining to, and I quote, the position of the great wife and the customary rules of succession, and concludes that, and I quote, her position of being a great wife in terms of the Zulu law of customary succession is not being contested. It's all referenced to custom. Then, and again, not contesting that part, shows that again the bona fides. They're saying we accept that, we go along with what was with the fact that that is the house that the appointment comes from, but she then moves on to where her differences are. Then at page 2487, she says, second last paragraph, a further consideration of an heir relates to the matrix of the custom of ukufakwa esiswini. It was the portion that Justice Nichols referred my learned friend for the President to. And then she goes on to describe in great detail, under the heading the custom of ukufakwa esiswini. and describes it. I won't read it all out. But crucially, in the concluding paragraph, she says, "It is therefore submitted that Prince Simakade Jackson Zulu, Isikhwankani, to His Majesty, is the rightful heir to the throne of the nation through the custom of Ukufakwa Esiswini." There you have it. She is saying that is the custom that has been overlooked, it has been breached. It's all there. Even if we stop at this, if the letter had stopped at this point, it was sufficient to activate Section 8.4 of the Judicial and Khoisan Leadership Act. But she goes on and says more. At page 2490 to 2491, she testifies about the respective customary positions, ranking and powers of the senior prince and the traditional prime minister. So at the bottom of page 2491, second last paragraph, she says, "Having regard to the contents in this subheading, it follows from the concise exposition herein relating to the processes forming the subject matter of this letter that any conduct and or act performed contrary to the accepted customary position in this regard is ultra vires and of no force or effect." So again, she's setting up the framework. She explains how the two positions rank in relation to each other, the senior prince and the traditional prime minister, and what their respective roles are. She gives the framework, and then later she's going to go on and say where custom was breached. And that she does at pages 2502 to 2508, where she takes the reader, in our case the President, through all of the events that led up to, the disputatious events that led up to the identification of King Misuzulu. And one must read that against the backdrop of her exposition of what the correct roles are of the senior prince and the prime minister. And wherever they differ, there is your breach of customary. She then concludes.
All right, Mr. Dodson, your 20 minutes of immunity is now over. I just wanted to give you time. I didn't want to break for tea before you have exhausted your 20 minutes. So when we come back, we are going to adjourn now. It's 10 past, so we'll be back 25 past, then we'll proceed. But your 20 minutes is up now. All right, thank you. The court adjourns.
Sexual assault. Okay.
But she escaped before
Anything.
40, he lists the great-great-great-grandchildren of King Cetshwayo, including those born of the late Queen Princess Mantombi Dlamini, as follows: A. Misuzulu, B. Ntando Sizwe, C. Mkhonsi, D. Bukosi Mbelo, and so on. And then a heading, affiliated, A. Simakade, added. And that book has the endorsement of both King kaZwelithini, I think he wrote the foreword, and it also has the endorsement of the late Mr. Buthelezi. He also has something to say in the book. So, it's not an issue we need to prove in these proceedings, but it's a demonstration that this is a serious contest that is there to be put up in front of the investigation committee. Another example, if I can refer the court to, and I should just add in relation to that, there was a strikeout application brought by Prince Misuzulu in respect of some of the evidence put up by Prince Simakade. This was not part of it. This is not part of it, so this is essentially uncontested. Then there was another example is the analysis that was done in relation to attendance at the 14th of May meeting by Prince Simakade. So what happened is the initial sheets of attendance registers were illegible. They were in handwriting, poor copies. But with Prince Misuzulu's answering affidavit, he put up typed versions. For the first time, that enabled those to be checked and analyzed. And if one goes to Prince Simakade's replying affidavit at volume 22, page 4312.
Page
4312. I beg your pardon, 4311. I beg your pardon, 4311.
Yes.
It starts at 69. Paragraph 5.20 of the answering affidavit is averred that all those who attended the meeting of 14 May were members of the royal family, as per the mandatory requirement of Section 8 of the Leadership Act. I strongly refute the assertion that all those who attended the meeting were members of the Zulu royal family, as per the mandatory requirement of Section 8 of the Regulatory Act. Many persons purporting to be members of the Zulu royal family who attended and participated were disqualified from attending and participating in terms of the second respondent's own definition of who forms part of the Zulu royal family. He refers to when he did it in his founding affidavit. There was an initial shorter list where he could recognize people, and then he picks up two people who are problematically included, and then 71. Indeed, an analysis of the attendees reveals a number of errors and misrepresentations of lineages of the attendees. Paragraph 7.12, the second respondent who asserts that the houses of the Zulu royal family, which are central to the decision-making process of the identification of the successors and form part of the royal family, the five preceding kings are those from the royal houses of Cetshwayo, Dinizulu, the royal house of Solomon, the royal house of Zulu, and the royal house of Scrutiny. However, the attendance registers annexed reveal that many of the attendees misrepresented their lineages, including Prince Buthelezi. This manipulation of lineages has the effect of purportedly bringing within the fold many members who ought to have been excluded from the royal family's deliberations. These members ought not to have participated in the decision-making process of the identification of the successors. Scrutiny of the transcribed attendance registers forming annexes to the second response answering it yields the following. And then he goes through and does a detailed close analysis to show where those are misrepresented, including starting with Prince Buthelezi and his daughter, Princess Pumzile. But he then works through, and I'm not going to take the court through all of them, but I commend it for the court's consideration, because it's carefully and logically reasoned in relation to each of the people that he deals with on that attendance register. And at page 4319, paragraph 74, he then draws the following conclusion. Having regard to the above, it is clear that the majority of the attendees who attended and participated in the purported identification meeting of the Scrutiny are not qualifying members of the Zulu royal family, as defined by the second respondent himself, last five kings, and or as set out in the Leadership Act. So that on its own, we consider the finding of this court in the impediment judgment, which says that the wrong people participate in the decision, it invalidates it.
Sorry, the decision of this court is?
Impediment versus impediment. The wrong people participate in that process, and that's the end of it. That leads to invalidity. And that's invalidity both in customary law, effectively, and in administrative law, and in constitutional law.
Mr. Johnson, with regard to Prince Mbonisi's allegations, I presume you part ways with him. He says that there's no great one. Anyone can be a successor, daughter or son. Ukufaka esisweni didn't happen regarding Prince Simakadi because the brothers would have known, and any of it is irrelevant according to him. Now, how do you respond to that?
We part company with that. We part company with that, and in fact, it's wrong to say that they disagree with Ukufaka because there is in fact a section of one of Prince Mbonisi's affidavits where he confirms the Ukufaka and says that he was involved in doing in ensuring that the relevant ceremonies took place. We'll find the reference for you. I don't have it immediately to hand. But we pleaded a case, and we stick to our pleaded case, which is based on both Misuzulu and Simakadi come from the house of and that's the source of the king.
So he says, Prince Mbonisi says there's no custom that the firstborn child is the predetermined heir. Do you agree with that, or do you not agree with that?
It's primogeniture. There is indeed such a custom. What I would accept is that that is the custom. But my experience in these cases, my reading of anthropology tells you that sometimes exceptions are made. So when I say that, I'm not saying it's absolutely hard line, because in fact one comes up with situations where primogeniture doesn't reveal an obvious candidate,
But your case here is that primogeniture is being followed, and the first son is Prince Simakadi, according to Fagoi Esiswe.
Yes. That's all.
Well, let's say Judge Davis was correct in the court below to set aside the recognition and direct the president to establish the investigative committee. Prince Mbonisi says, the matter should have been diverted to the royal house. That's what he says, Prince Mbonisi. He doesn't want a diversion to the investigative committee. He wants the matter to go back if the decision is set aside to the royal house, royal family.
It seems to me that, and my junior counsel will kick me if I'm making the wrong submission here, but it does seem to me that if one follows the logic of the relief they seek, which is that they want to undo the decision of the 14th of May, if that is set aside on review, then it may well be that the only logical relief that flows from that is that it has to go back to the royal family.
Okay.
But that's not our position. Our position is that yes, we agree with Prince Mbonisi that 14th of May meeting was fundamentally flawed. But we say that's a reason to apply Section 8.4. Part of the reason to apply Section 8.4, that was one of the customary failures, was that meeting going wrong. And we say it must be channeled And in fact, we say that the legislature, the Section 8.4 provision is interesting. As we saw from the Chibumo case, the previous wording of the national local government traditionally is Framework Act said may also.
And this one says must.
So the legislature switched it to must. And there's a presumption that when the legislature changes the language, they intend to change the meaning. They want to work differently.
Yeah.
And they changed it to must. And what it seems to us that suggests that what the legislature wants is that these disputes must be channeled into that investigative committee process. And that's where they must be dealt with. And there's an enormous amount of sense to this. It means that festering disputes don't go back to a place where the festering started. They get channeled into a professional dispute resolution situation. They get dealt with through investigation. It can be a public process that has accountability and transparency, and hopefully one gets to a resolution.
Well, but that approach on Prince Mbonis's argument, it's not an approach that will give effect to the rights of the royal family to identify, because that's a basis upon which he feels the royal family has been aggrieved. It wasn't given the right to identify, to participate in the identification process. So, what do we do here? Well,
we respect that. There's an entire. The fact of the matter is the president made his decision. So the handbrake that this court laid down in the paper, where they said the handbrake stays on until the recognition decision has taken place. Once that's taken place, the handbrake is off for both the identification decision and the recognition decision. And the identification decision becomes part of the administrative action that is subject to review. There's in fact an incorrect submission in Prince Misuzulu's heads that administrative action doesn't relate to the identification process. It does, but it's only perfected once the recognition decision has been made. So we respect it. We originally, I should say, in fairness to Prince Mbonisi, we originally also challenged on review the identification decision. But we realized that would channel it back there. And our concern about going back to the royal family is there is a real risk of more disputes and more litigation. If you look at the papers in this case, Deputy President, they don't agree with each other about what how the royal family is constituted. But there's potential, if we go back to the royal family, with all due respect to Prince Mbonisi, for this thing to really drag on and drag on and drag on.
as well as on whether or not there is a customary law and custom according to which the identification should take place. Because according to Prince Mbonisi, there is no sort of established custom.
I beg your pardon, there's no
Established
custom.
It's sort of it's very fluid, if I might put it that way. It depends on the situation.
If it's fluid, then it illustrates the point I'm trying to make, because if it's fluid, it's going to generate more disputes. The advantage of going to the investigative committee is if they struggle with that part of the customary investigation related to identification, they're entitled to move on to the substantive question of who should it be, Prince Makadi or Prince Misuzulu. And they can get on with it, and they can come up with the result. What we do ask, and what Judge Davis did not give to us, is that there be mechanisms in terms of Section 8.1c, I think it is in Pretoria, that ensure that the process is fair. We have to remember we started off here with a wrong decision by the President, aggravated by the fact that he has, both in public and in these proceedings, openly sided with Prince Misuzulu. That's a problem. That's a problem, because he is in charge of that dispute resolution process. He appoints them, they go and report, they come back to him, they deliver their report to him, and he, in terms of 8.5, makes the final decision. So that's a worry. We say that's what Judge Davis should also have included in his judgment and didn't include, is to ensure that all of the parties, Simakade, Misuzulu, Bonisi, they all have an input protected by court order to comment on who's chosen for the investigative committee. They all have an opportunity to obviously give evidence before the investigative committee. They all have an opportunity to comment on the report that emerges from the investigative committee. So that is provided for both through the channel we discussed earlier on the application for leave to appeal and into the notice of appeal, and we set out a draft order in the notice of appeal that provides for it.
And the investigative committee, the composition thereof, that's the prerogative of the president, you say?
That belongs to the president, but we say we build into the draft order a mechanism for him to say, here's my proposal, you've got X number of days to comment, and then I'm going to make my decision. If I can then just make a brief submission about the wording of Section 8.4 insofar as it uses the words evidence or an allegation. We say that the fact that the legislature used two words and not one needs to be respected because there's a presumption against tautology. The definition of allegation in the shorter Oxford English Dictionary 2007, that's in fact the big one, even though it's called shorter, is as follows. This isn't in our heads. It is, first they say the action of making a charge before a legal tribunal, a charge so made, or, second meaning, an excuse, a plea, and alleged reason. Third reason, a claim or assertion of wrongdoing, especially one made without proof. So we say that that too points to two possible triggers that can set it off. You don't have to, if one has regard to that interpretation of the word allegation, you don't have to actually come up with your evidence to be able to enable the President to activate Section 8.4, as long as there's at least an allegation. So if the court is against us in relation to the letter from Princess Temi on the basis that it doesn't contain evidence, we say it does, and what she says is recognized evidence, but if the court is against us, it certainly falls under the category of an allegation as defined.
Well, but Mr. Dobson, I think that the allegation must be such that it constitutes a sufficient basis for the President to conclude that there was the identification was not in accordance with custom. Well, I'm sure that would be a threshold. Otherwise, then would allow any vexatious.
We would concede that. What we would submit is the interesting case is Chibumo, because Chibumo was a higher threshold because it required the President to exercise a discretion.
Yes.
But even then, if you look at what happened with the Chibumo family were a headmanship or headwomanship. In fact, they had a headwoman before. And what the court pointed out is that you, Chibumo, headmanship or headwomanship, can't claim to have a royal family because the legislation is built around traditional communities, not headmanship/headwomanships. So you can't have your royal family. So your case that you came with on the basis that you were the Chibumo royal family can't fly in terms of the various definitions in the Traditional Khoisan Leadership Act. But the court was still willing to say, Premier, you should have referred that to the national houses for their recommendations because there was a customary law dispute. So we say the threshold is low, and there's nothing wrong with Judge Davis is having said that the threshold is lower. And if there is any evaluative process, it would only go so far as saying, is this on the basis of Chibumo, or is this vexatious, or is this frivolous? And yes, I would concede that the President would be entitled to filter those out of the process. But I think the legislature wants to get these disputes into a formal dispute settling mode rather than letting them fester in the way that even this one is also festering terribly. So those are the submissions in relation to the wording of Section 8.4. An issue that I wanted to deal with, because it came up yesterday, is the issue of Prince Simakadi's letter of the 11th of May. And we most respectfully submit that, again, Prince Simakadi's letter is being misunderstood.
Well, what does he want to convey in that letter? What is he saying? Is he saying I'm available or I'm not available? What is he saying?
There's a whole lot of things.
This is very it's very ambiguous. It's just like a person who is sitting on the fence.
Can I be allowed to answer it?
Yes.
Like a lawyer? And that is to say, context is everything. And I'd like to the court just to bear with me to provide the context as set out in his filing affidavit, because I think it provides a firm basis on which to understand what the meaning of the letter was. So if we go to page 2730, which is in volume 14.
Yes. You are there?
So he describes the developments. He says the late Queen passed away on 29 April and the memorial service in honor was hosted at the Palace on the 7th of May 2021. At the end of the memorial service, Prince Buthelezi stood up and announced to those present and to the media that he had been called by the lawyers for the late Queen, requesting a meeting in order to read the final will and testament that the Queen had left. He announced that the meeting would be held that same evening, 7th of May, at the Palace, the late Queen's Palace, and the venue where the memorial service was held. Accordingly, a meeting was opened to the public and screened live on TV. Will was read by Advocate Griffiths Madonsela. He informed all present that the late Queen had nominated Prince Misuzulu as the next king of the Zulu nation. This gave rise to a number of queries and concerns as to the legal validity of the Queen's purported nomination and its status. The meeting descended into chaos as Prince Buthelezi denied members of the royal family a chance to ask questions, and the police were called upon to remove Prince kaZwelithini of Kwantla Mahlala, who ultimately did not do so. No one else was allowed to speak in that meeting except for Advocate Madonsela and Prince Buthelezi. Prince Buthelezi announced that the succession debate was closed. The following day, 8 May, Prince Buthelezi again addressed the media and reported that the matter of succession had been settled with the reading of the will, and as far as he was concerned, the king is already on the throne. Prince Misuzulu was addressed by Prince Buthelezi as the king and given the Bayete salute that only kings are given. Thereafter, on 9 May 2021, the Premier of KwaZulu-Natal visited the palace, purportedly to pay his homage to the newly announced king. I understand that notwithstanding that there had been no identification decision by the royal family, the Premier brought cattle with him, which he presented to Prince Misuzulu. On the 10th of May, the KZN Premier spokesperson, Mr. Lineage is quoted by the media as having said that the Premier would announce the date for the coronation of King Misuzulu. I was not involved or consulted about any of the foregoing developments of the instance of Prince Buthelezi. I knew that the customary procedures for identifying the new king had to take place, and were taking place, and I assumed that everything was being done lawfully in this regard. I did not participate in any meetings of the royal family to deal with the issue of succession, although I attended the subsequent meetings of 23 May and 5 September 21. I highlight in this regard that recognition of the successor is not a matter of voting or candidature, but a matter of the proper application of customary law. While I was trying to come to terms with events, and following upon announcements in the press and press coverage, I received a barrage of calls from the media, supporters and other members of the public. I preferred not to deal with the media. I therefore decided that it was in my best interests and those of the Zulu nation to ask Prince Buthelezi to intervene with the media given his function as the spokesperson on certain matters affecting the Zulu nation. I therefore decided to address a letter to him. On the 11th of May, and against this background, I addressed correspondence to King Misuzulu, indicating my intention to abide what I understood to be the decision of the royal family. I quote this letter in full, as it has respectfully been misused and misinterpreted against me. I annex a copy of both the Zulu version and a sworn translation of the English translation of the letter, together with a certificate from the sworn translator, Cyril Language Services. The court will have seen that the other version that we were looking at was a Strauss Daily production, the attorneys for Prince Misuzulu at that stage. We submit that this translation is the one that was available, because it has been prepared by a sworn translator. And then he reads the letter, and I'll come back to the letter. And in 125 on page 2734, he says, I emphasize that I wrote this letter in the past tense on the assumption that a proper process, both statutory and customary, had been followed, and that the outcome which I was bound to accept if the process was properly conducted was that Prince Misuzulu had been appointed as a seal. Had I known what I subsequently discovered to have happened, i.e. that neither the correct customary law nor the correct statutory processes had been followed for the appointment of Prince Misuzulu, I would not have sent the letter, at least in the form that it was. As the letter clearly conveys, if there had been a proper process and I had been nominated, as I ought to have been, I would have accepted my nomination to the position of king. Now, questions have also been asked about why there had been this meeting on the 5th of May. He wasn't talking about that in his document. To get the answer to that, if I can ask the court to go to 4305.
So what,
4305.
Volume?
And that is in volume 22. Sorry, 4304. 4304 in volume 22.
Yes.
Reading from paragraph 50, the allegations around the secret meeting. The second respondent from paragraphs 15.3 to 15.14 and elsewhere make certain false statements pertaining to the asserts of a secret meeting orchestrated by my supporters to identify me as king. These averments are false. Yes, evidence based entirely on the draft affidavit of Prince Buthelezi. They will be included in the striking out application. Suffice it to say that I stand by what I said in my prior affidavits regarding the meetings, giving rise to my lawful identification as king. The attempt to cast suspicion over the meetings by describing them as secretive and orchestrated is contrived. They were probably called and conducted. The precise nature of the meeting of the 5th of May 2021 is set out in my founding affidavit. It took place amongst the most senior members of the royal family, and this is entirely consistent with custom. Prince Buthelezi is not part of the senior members of the royal family. 15 of such members attended. They are listed in paragraph 106 of my founding affidavit. As is pointed out in the founding affidavit, although I was nominated there were additional members of the royal family from other houses that were not represented at that meeting and who needed to be consulted. A wider consultation was agreed to take place at the meeting of the 23rd of May. There was also a delay, this is the important part, there was also a delay in the outcome of the meeting of the 5th of May 2021 being made known, again consistent with custom. Even I did not know the outcome for some time, and that is in part why I was under the misapprehension when I wrote the letter of 11th May 2021 that the outcome of the identification process had been against me. So if I can ask, against that backdrop, that we then return to the letter at page 2733. Unfortunately, these references aren't in our heads of argument because the issue has come up in the course of the debate yesterday. If I can ask the court to go back to the letter at page 2733 in volume 14. And if I can ask the court to start at the end, the bottom of the letter. It says, I request the Prince, as he reads the statement in its unaltered state, to also ask the journalists to desist from calling me about this matter, because there is no further information I can give in addition to what I have already stated. So
So when he writes the letter, he's already been nominated by the meeting of the 5th of May.
he doesn't know about it.
He doesn't know that he's been nominated by the 5th
He
of May.
doesn't know about it. That's the paragraph I just referred to in the reply affidavit. He doesn't know he's been nominated. It's also important to bear in mind that already on the 5th of May, they recognized that the identification was incomplete. In fact, his identification process involved 3 meetings. 5th of May, 23rd of May, and I think it's the
September.
5th of September. Those 3 together give rise to the identification. He does not know at the time of this about what has happened on the 5th of May. And there's I can't remember why they were described as secretive, but it kind of ties in a little bit with that averment. So
Well, sorry. This letter is written on the 11th of May. The statement is dated the 11th of May, which I assume is the date on which it was written. The meeting at which he was nominated took place on the 5th. So between the 5th and 11th, he was in the dark as to
Indeed.
the outcome of the meeting.
Indeed, that's his uncontested evidence. So his problem is he's getting pestered.
But hang on now. You've got a situation where a person does not know whether or not I was nominated, but he is worried. He asked Prince Mangosuthu to say, please intervene here. Why is he so worried? Why is he worried? To just understand that he asked him to read the statement.
Because he's being harassed by the press. And Prince Buthelezi is the logical person to deal with the press. That's what's clear from this last paragraph of the letter. I request the Prince Buthelezi, as he reads the statement in its unaltered state, to also ask the journalists to desist from calling me about this matter, because there is no further information I can give in addition to what I've already stated. And please leave me alone.
Well, there's somewhere where he says that I'm aware, Makeba, that there are rumors suggesting that there may be people who wish that I should take the position. So there's something that he knows. He's aware of something.
He's heard rumors. He's heard rumors.
What is the nature of those rumors? And where do they come from? Is it from the media or from...
He's saying, he's obviously getting pestered by the press, and he says in the first paragraph, I request the Prince to read this open statement on behalf of his. He's not saying anything about any meeting that's coming up or anything like that. He's saying, I'm being hounded by the journalists. You're the guy who deals with journalists. Please read this. It's a press statement. He's saying, please read this press statement to the journalists.
He's nominated on the 5th. He hears these rumors. He doesn't go back to anyone and say, hey, what happened at the meeting of the 5th?
Because he doesn't, I don't think he knows about the meeting. I don't think he even knows about the meeting that took place on the 5th. I should take this position. I cannot do anything about other people's feelings.
But isn't this, that this might be what he's talking about the 5th of May? That there are people who are suggesting that I take this position.
it might be that those are the source of the rumours. He acknowledges the rumours, but he says, and it's a disciplined position, it's a respectful and disciplined decision, which he goes on to explain in the next paragraph. I want to state that my aunt, the princess who is married to the Ndlovu family, I think it's Princess Tembi, and the Prince of the Kwezi house have advised us as the King's children that if the King or Queen chooses one of us, the one who is nominated should accept the nomination. Therefore, I would have accepted the nomination had I been selected. And they had also advised that we should accept and support whoever is nominated. And bear in mind, there's been a sequence of meetings that he is aware of, where Misuzulu is the person who's been appointed as king. No,
Well, according to the instruction or that was given to them by his aunt, Princess Tembi, to say, you must be behind whoever has been nominated. Why was he not behind Prince Misuzulu?
Because
as per the instructions by your aunt.
At this point he was. And he's saying, at this point effectively he was.
What changed then?
He was saying he'd been told by Princess Tembi,
yes,
that if the King or the Queen chooses one of us, and the Queen in fact chose one of them, they must accept it. At this stage he's accepting it. He's entitled to discover later on that without his knowledge, there's been a process underway in which people actually want him. And he has confirmed in this letter, to say, therefore I would have accepted the nomination had I been selected. He's entitled to say that. And let me take the court to where...
Okay. At what stage then did he become aware that King Misuzulu had been nominated?
I'm not exactly sure, but he attended the meeting of the 23rd. So certainly...
Because we have got a situation where a person has been... There are standing instructions from the senior member of the family to say, you must be behind whoever is nominated. In due course, King Misuzulu is nominated. In accordance with the standing instruction given by the senior member of the family, one would have expected him to have complied with the instruction by supporting the nomination of King Misuzulu.
And that's
why did it happen here?
And that's exactly what he's doing here. He's saying, read a press statement, not, by the way, use this letter to read out at some nomination meeting on the 14th that I don't want this position. That is not what this letter says, by any stretch of the imagination. And I'll show where that misconception comes from. It comes from the unsigned affidavit of Mr. Buthelezi. He's saying, read a statement to the press. He's behaving in the way that he's been told to behave. But the reality is, in the background, there is a process underway that he is unaware of that wants to nominate him. He's got a letter on record on the 11th that said, had I been nominated, there's been a series of meetings which suggest that he's not nominated, that Misuzulu is. And he respects that. He even goes as far as getting this press statement read to say to the press, leave me alone.
So on his version, he became aware of the competition, let's call it, between him and King Misuzulu was on the 23rd of May.
I don't know. I'm speculating. And I know that he attended that meeting, so that must be the latest point at which he'd become aware of it. I don't think it's on the papers the point at which he did in fact become aware of it. But certainly by the 11th that he had not. And if I can just take the court to the unsigned affidavit of Buthelezi, because we see where all the confusion is being generated around this letter. The court will just bear with me to find the reference. It's 3827. Volume 19. 3827, volume 19.
Sorry, what's the page number?
The page number is 3827 in volume 19.
Must be volume 20. It's 20. 3827.
volume 20, 20.
Yeah, it's true. It's volume 20. Yes.
So, what is purported to have been said by Buthelezi in an unsigned affidavit is, however, in the days leading up to the meeting of 14 May 2021, there were rumours, principally from the media, that Prince Makadi was mooted as the possible contender for the heir to the Zulu throne. I contacted Prince Makadi in order to verify if the rumours were true. I did so in order to deal with the matter at the royal family meeting of 14 May. Prince Makadi made it clear to me that the rumours were false and that he had no ambitions to become the heir to the Zulu throne. In order to make this clear, I requested him to record his position in a letter for me to convey to the members of the royal family and the world at large. On 11 May, Prince Makadi penned the letter and requested me to publish same to the media. The letter is attached here too. In that letter, Prince Makadi expressly disavowed any claim to the throne. Now, compare that with the actual content of the letter. That is where all of the misconception has arrived, and it illustrates the prejudice of that unsigned affidavit. This unsigned affidavit has been brought into these proceedings to give the wrong impression that that press statement, effectively, of the 11th of May is something in connection with the letter of 14th of May. There is nothing in the letter of the 11th of May that says I disavow the position. There is nothing in the letter that says there's a meeting of the 14th of May coming up. There is nothing in the letter that says, please read out this letter to tell people that I disavow any claim to the throne.
But it says I can confirm that I have not told anyone that I have this position.
Sorry,
I can confirm that I have not told anyone that I have this position.
Yes. Yes, he doesn't covet the position. He doesn't covet the position. He's been told. That's what his elders have told him. You mustn't covet a position. You must sit, you must wait, you must see what the elders decide, and when they decide, you respect their decision. So saying I don't covet the position, he's saying I don't have o'erleaping ambition, I think, to use the words from Macbeth.
Desire.
I don't have o'erleaping ambition. I'm a disciplined member of this community. And I wait for the elders to tell me what to do. And it's got the, I do not covet this position, has to be read with the part that says, if I had been nominated, I would have taken the position. How can you take that letter and read it out at a meeting to say he has disavowed any claim to the throne? And what's happened is, this unsigned affidavit has infused these very proceedings here in the Supreme Court of Appeal.
Sorry, Mr. Dodson, but at least that unsigned affidavit did not find its way in the Pietermaritzburg court proceedings before Madondo AJP. You see, Madondo AJP does refer to this letter, but this affidavit, unsigned affidavit of Prince Mangosuthu, is an unsigned affidavit for the purposes of Pretoria High Court proceedings.
Yes.
So, in other words, the point I'm trying to make is that we do not have the record of the proceedings in the Pietermaritzburg High Court, other than the judgment of Madondo AJP. But Madondo AJP at 109 does make a reference to this letter by Prince Simagate.
Completely impermissibly, with respect.
Well, I don't know how it found its way into the court record, or was it annexed to an affidavit, but I assume that Prince Mangosuthu Buthelezi might have signed an affidavit, or he might have submitted this letter before Madondo AJ by way of an affidavit.
Indeed.
Yes.
But the position, and it's part of my subsequent argument that I'm coming to, is if you look at what took place there, very important to respect the silos in terms of the evidence. Two applications are brought. One to determine the consequences of a civil marriage, being his first marriage, the other to challenge the validity of the will. I don't know when exactly they began. We can work it out from the notices of motion. But those are two bits of litigation that are underway in the first half of 2021. The Prince Mbonisi application is brought when there's a rumor of a coronation in November 2021. That, we've got the papers, we've got the founding affidavit, and we've got the answering affidavit from that application. So we do have those pleadings. We don't have the pleadings from the other cases, as Deputy President, you've absolutely correctly pointed out. And the question I asked, just to pause there, is how on earth do we fairly to Prince Makade adjudicate the question of res judicata when we don't even have the pleadings from those two cases? They cannot be used against him in any way. So if Judge Madondo has taken averments and affidavits that we don't have from those first two cases and transported them into Prince Mbonisi's application to proceed on his decision to settle the succession dispute, there cannot be res judicata because there isn't a pleaded basis for him to have done so. And we know there isn't, because if we look at the founding and answering affidavits, there is not a mention of the 14th of May. Prince Makade's name appears nowhere in those founding and answering affidavits. And I'll give the reference.
But doesn't issue estoppel apply to the meeting of the 14th, the identification process?
Not at all. We don't know where that evidence comes from. We can't even see the affidavit.
But that's what a court has determined. A court has determined the outcome of the 14th of May. Are we entitled to determine it again?
Absolutely, if it was not a pleaded issue in dispute in that case.
No, but it was an issue. We know that the identification.
It wasn't an issue.
Because Madondo tells us
it was not.
One of the
we can tell 100% that it wasn't an issue in the case because we have the founding and answering affidavits. That must be determinative. And if the court decides something that is not an issue pleaded between the parties, it was on a frolic. This court can't be bound by a frolic of a judge who decides something on the basis of evidence that isn't before him.
But at least in respect of two applications, Madondo AJP does identify the nomination as one of the issues that were before him, at least in two applications.
In the first two applications, and if you look at how he deals with those first two applications, in the Mbonisi application, he says those cases do not raise the succession dispute. He says it expressly. I think it's paragraphs somewhere around about paragraph 83, 84, 85. He specifically says the issues there did not involve the succession dispute. So that's his assessment. That's his assessment, and we must be bound by that. And the cause of action for seeking an interim interdict was those two applications. Pending those two applications, Prince Mbonisi said there should be interim relief that prevents appointments and all that kind of thing. But it was linked in with those two applications. Madondo points that out.
But let's look at page 153.
1.5?
Page 153 of volume 1. These are the issues that are being identified by Justice Madondo under case number 10879. And one of the issues relates to paragraph C. King Misuzulu was legitimately and appropriately identified and nominated as the successor of the late.
Yes. He's written it in the judgment, but we've got for ourselves the pleadings, and it doesn't raise the issue. Also important in this context to remember is there was no consolidation between the first two applications and the Prince Mbonisi application. That's contained in paragraph 1, the very opening paragraph of the judgment. He says, makes it clear, initially it is a bit unclear, it suggests it might be joined to Ward, and then he makes it clear. He says, I joined those two, and then I directed that the third application be heard together with this application. The other important thing, Justice Bachane, is that if you look at his reasoning in the judgment, there are 2 points. There are 2 exit points, if I can call them that, where he has already been through a reasoning process to be able to arrive at the relief that he grants, which is to dismiss this application. The first one of those, if the court will just bear with me, is paragraph 80. He says the date of 3 December, that's when this coronation was meant to take place, has come and gone without the alleged coronation taking place, notwithstanding the fact that this court declined to grant the urgent relief sought on 2 December 2021. As a consequence, it is now common cause between the parties that there is no coronation implicating public funds underway. The application has in fact become moot and irrelevant. So anything that he says after that point is arbiter.
But in any event, Mr. Dawson, the judgment of Madondo AJP is not before us on appeal.
Indeed.
Well, that's it.
Indeed, but its analysis, is it going to assist us? This court is entitled to look behind and look what we've
Well,
done.
there are no pleadings. I mean, we could do that if we've got a complete set of pleadings that serve before Madondo AJP and the judgment, and then we can say, okay. But only if it is properly before us.
But we have the pleadings, Deputy President. We have the pleadings before us. And I can take the court to them, if the court will bear with me.
The pleadings in relation to all 3 applications?
No, but the pleadings, but importantly, the pleadings in respect of the case where res judicata is pleaded, the only case in which res judicata has been and can be pleaded is in the Prince Mbonisi application. Nowhere else. That's even on Judge Madondo's version, because he said that the leadership dispute does not arise in the other 2 cases. So even if we found the pleadings there, and they said something about it, it's clear, and it's clear also on what the central focus of those cases was. They're not decided there. So we are front and center, and the only place we are in is in the Mbonisi application. And there we have the founding affidavit and the answering affidavit. Let's go through them. They do not deal with this issue. And this court is entitled to look at the pleadings to see whether the judgment fairly reflects the pleadings. Just before I move off there, and while we're still busy with the judgment, if I can just complete the other submission that I was making in response to Justice Patswane, which is the other exit point that rendered it moot. And if the court will just bear with me to go back there. The other exit point is at paragraph 84 on page 156. It says, the applicant prints furthermore, this is at the bottom of paragraph 84, the applicant prints furthermore does not state whom he represents. Applicant Prince has approached this court on misinformation and incorrect facts. He eventually submitted that there is no official coronation of Prince Misuzulu utilizing public funds underway. Consequently, the applicant has not made out a case for the relief sought in the notice of motion. Boom. That's the end of the case. Anything that comes after that is his musing. It's his musing. We all know. Justice Madondo, he's written a book on customary law. He's interested in this stuff. It's a helpful little book that he's written on customary law. It's his interest that he's pursuing, and he should not have pursued. This court has said repeatedly in recent times that a judge must stick to the pleaded issues between the parties and may not go beyond that. Now, if it's clear on the pleadings that he has done that, this court cannot be held bound from a res judicata point of view by that judgment. If one looks, for example, at the D'Souza judgment of Justice Wallace, he looks. So there the case was whether a decision of the CCMA effectively determined an aspect of the litigation in front of him.
He looks at the pleadings very carefully. He goes back and analyzes and looks at what the transcript actually said of the evidence. He looks at that to see whether it should in fact be binding. And this court of all courts, sitting in the hierarchy where it does, with respect, cannot say, we're not going to look at the pleadings. In fact, if there's a...
Can I just get this quite clear? So after 84, you say the rest of the judgment, after paragraph 84, the rest of the judgment are basically his musings on customary law.
It's arbiter.
And we should...
Put a pen, for purposes of res judicata, put a pen through.
After 84.
Indeed. And it's reinforced by the fact that he says, anybody who wants to review, if you come to my court, I would have chucked you out on the basis that you were here prematurely. That confirms that this is arbiter. And arbiter, what's interesting in the Mkhize judgment that my learned friend referred to is the link that's drawn between precedent and res judicata, how they operate in tandem. Well, what does that tell us? It tells us that if something is arbiter, it can't be binding for the purposes of a plea of res judicata. The other point that we make is this: if there is a shortage of evidence to show what went on in the case and to show the pleadings, that shouldn't be something laid at the door of Prince Simakade. It should be laid at the door of the party raising res judicata. A responsible raising of res judicata in this case required Prince Misuzulu, with his answering affidavit, to raise it, to gather all the pleadings, any evidence that was led, all the affidavits, and attach them to and explain them in his answering affidavit. It did not happen in this case. They ask us to look at heads of argument that were found, heads of argument on pleadings. They can terribly misrepresent what the case was all about. The other important point to bear in mind is that, and in fact it's not adequately acknowledged in the judgments on res judicata, is we are talking about Section 34 of the Constitution. The application of res judicata to exclude a litigant is a limitation of the litigant's rights in terms of Section 34 of the Constitution. And for that reason, the courts need to approach it very, very carefully. It's acknowledged even in some of the earlier judgments that a tremendous injustice can be done by a plea of res judicata. Long before we had a constitution, we now have Section 34 that guarantees the right to be heard in front of a tribunal. This case is unique because it's not just Section 34. It's Section 34 and it is Section 33.3. What the appellants in this case asked this court to do is extraordinary. They say, because of an arbiter judgment of Justice Madondo, Prince Simakade must be denied both his constitutional right to review administrative action and his right to have a hearing before a court of law in terms of Section 34. That is unprecedented. And if one looks also again at the Mkhize judgment that my learned friend referred to, the Mkhize judgment, you'll recall, it involved an extraordinary flurry of litigation. I had great sympathy for Justice Philpott because it must have been a pile of paper this high. There were applications, counter-applications, interlocutories. The list was endless. But through all of that, what the Constitutional Court does is it jealously guards Mrs. Mkhize's right to judicial review. Very carefully. You'll recall that she was trying to pick up, because her husband had litigation related to traditional leadership issues. He'd been appointed and his appointment had been withdrawn. He died before his litigation, his review had been resolved. And the court, the Constitutional Court, was at pains as far as possible to protect her right to take over that review. They said to her, okay, you can't pursue your review insofar as it asks for you to be, insofar as he was asking to be reinstated in his position as traditional leader. But what you can do is pursue it in all other respects, to protect your son's claim, to protect the monetary claim from the salary that he should have got, which you would inherit. The court is, and the court comments on the fact about the importance of a right of review. The Ota judgment of the Constitutional Court as well makes the point that one must be very careful in interlocutory litigation about usurping what the reviewing court needs to do. Yes, it was speaking in an appellate context, but I submit it's of equal application throughout the court process. Be careful where somebody has a constitutional right of review that you don't, through a ruling in an interlocutory, deprive somebody of their rights. And that is exactly what the appellants are asking this court to do, to sanction a deprival of Prince Simakade's right to review that decision. Another component of it, Prince Simakade, before the president has even taken his decision under 8.4, says openly, there's no basis for you to exercise your powers under Section 8.4. How on earth can a judge with the greatest of respect to Justice Madondo do that? It is a preeminent breach of the separation of powers. It's a preemptive strike on the president. And the president should have treated it as a serious incursion of the separation of powers. How could he do that? And this court, with respect, that automatically renders it arbiter. You make a ruling on an event that has yet to take place. How on earth can that have any binding effect? It cannot have any binding effect. It has to be the most arbiter of arbiters if one is to do that. Yet that is what our learned friends ask us to do in these proceedings. The other important aspect in relation to this litigation, let's assume that Prince Simakade was served in relation to this litigation. With the greatest of respect, why on God's earth would he get involved? If he's got a pending potential review, why on God's earth would he get involved in, with all due respect to Prince Mbonise, an extremely ill-advised interim intellect application?
Are you referring now to the High Court proceedings in Pretoria? Or
The High Court's?
Proceedings in Pretoria?
No, I beg your pardon. No, I'm talking about justice. I'm talking about the proceedings in front of Justice Madondo.
Okay.
I'm talking about the proceedings. I beg your pardon, Deputy President. The rhetorical question I ask is, why on earth would Prince Simakade, if he had been served, get involved in those proceedings in Pietermaritzburg, which are being brought on the basis of rumors? How can you bring an urgent application on the basis of a rumor? And what everybody's saying is, yeah, you should have joined that application. Why? You could see from 1,000 miles away the application was going to be dismissed. Nowhere in the founding affidavit, and I know I've promised to come to them, is his name even mentioned. Nowhere in the answering affidavit is his name even mentioned. Why on earth would he get involved in in a fool's errand? There was no reason for him to do so, and to deprive him now on that basis of his right of review would be completely contrary to what the courts have warned against with res judicata, that you can inflict terrible injustice on people by doing that.
But did he not get involved by virtue of his confirmatory affidavit?
No. His confirmatory affidavit pertains to the second application.
Oh.
And in fact, it's a helpful kind of pointer, because if I remember correctly, I think he signed it stamped on the 25th of May 2021. And Prince Mbonise only starts his application in November 2021. The very interesting thing about the joinder issue is that one of the reasons in that last extract that I read, where I say was the second exit point after which it became arbiter, one of his complaints is the non-joinder of the two princesses who brought the will application. Now, if you look at this document that's been circulated this morning in the application brought by my own friend for the President, their two names appear in that same Annexure A that Prince Simakade does. Yet, Madondo says in that same, Justice Madondo says in that same paragraph, I'm dismissing this application because he failed to join the members of the royal family. So it didn't, as far as Justice Madondo was concerned, it didn't satisfy service if you were already in those other two applications. He clearly wanted fresh service. And it also didn't help if you stuck Annexure A to your notice of motion and included names there, including those two princesses, and said, thereby, you're somehow served. I am confident that there was no proper service in respect to that. I may well be proven wrong. But what we did for this application is we served properly on the royal family. We arranged for the Deputy Sheriff to go to every single palace. We arranged for publication in the press. All of these steps set out in order to ensure that there was proper service. I seriously doubt whether those steps can be seen, they're part of the record. I seriously doubt that took place in relation to this. But I may yet be proven wrong.
I must just warn you about your 2 hours that was allocated to you. But yeah, you may proceed. Just to make sure that you have almost exhausted your 2 hours.
Does my head get chopped off at 1 o'clock?
No, we can proceed until 1 o'clock.
As the court please, that the court will just bear with
just
me.
To make sure that if you still have some more submissions to make, then you.
Deputy President, would it be possible for us to take the lunch adjournment now? I can do a quick audit during the lunch break to see what I have or haven't covered, and I have 10 minutes when we restart.
Do you have anything to say now or before we adjourn?
No. If we could just have those 10 minutes when we come back, that would be greatly appreciated. We certainly need to say something about relief.
Your submissions have covered your cross appeal. You remember you've got a cross appeal.
I think they have.
Just make sure that
yes,
you have covered.
Yes, I've got submissions to make in relief, just to make sure that we're clear with the court as to what it is that we're seeking and explain it. But I think I have covered our cross appeal substantially.
Okay, then you'll wrap up when we return.
Indeed, Deputy President.
The court adjourns until 2 o'clock. Thank you. Yes, Mr. Dodson.
As the court pleases, Deputy President. Deputy President, in my conclusion, I'm mostly going to just give references to clarify certain issues with some brief submissions before I deal with relief. Justice Patwane asked about the methodology of the mediation panel in relation to how they gathered their evidence. If I can just give a reference for that. It's at volume 8. Page 1527. So 1257, my dyslexic kicked in. 1257 and following. The pleadings for the Imbonisi application are the founding affidavit at page 1970 in volume 10. There, if I could just perhaps ask the court to quickly refer to that. So volume 10, page 1970. If I could ask the court to go to volume 10, page 1970. That's the start of the application. I just want to have a quick look.
Just give me a sec.
I beg your pardon, Deputy.
Got it, yeah.
There's volume 10. It starts, just to give the pages for the founding affidavit, it's 1970 to 1989. 1970 to 1989, but there's a particular page I'd respectfully ask the court to go to, which is 1987. And that's paragraph 12.2 at 1987, where they deal with the prima facie right. So this is the underlying cause of action that they're motivating the interdict on the basis of. He says, I have a right and interest in the affairs of the royal family, in particular the outcome of the pending consolidated applications. So that's a reference to the will and the civil marriage application. 12.2.2, I have a right of access to court and to have any dispute resolved through the application of law in a fair public hearing in court. 12.2.3, I assert that as a member of the royal family, I have a right to insist that there must be compliance with the law and the Zulu customs and its practices. 12.2.4, accordingly I submit that I've made out a case showing the nature of the right I want to protect. No reference in the part where it should be housed to finally resolving the traditional leadership dispute. We can then look at the answering affidavit. The answering affidavit is at page 1990 to 2002. And if I could just ask the court to please have a look at paragraph 10 quickly on page 1993. 1993. And one sees there Chief Buthelezi summarizing the issues as far as the Imbonisi application is concerned. Firstly, the applicant has no longer standard to bring these proceedings. That's 10.1. 10.2. Secondly, there is a material non-joinder of necessary parties, in particular the African Queen and the case that Queen Sibongile Winifred Zulu. That gets expanded on later in the affidavit where he refers to the entire royal family. Thirdly, the matter is alibi lis pendens and is yet to be determined by this court in fewer than 5 days from the time this urgent matter has been set down. Fourthly, the matter is not urgent and no grounds for urgency have been established. finally, the application is misguided and the applicant has no right prima facie otherwise to the relief he seeks. The official coronation is envisaged in terms of Section 17.5 of the KwaZulu-Natal Governance Act is not imminent. So again, no reference to deciding anything in relation to Prince Simakade or an overall resolution of the traditional leadership dispute. I also mentioned that Mbonisi in fact supported Prince Simakade on Ukupakwa, and just to give the reference there, I do not ask the court to go there. It's volume 18, page 3525, at paragraph 104 and following. Covers about 2 pages. Then briefly, a point not covered, I don't think, in our heads of argument, is that the President was requested by Prince Simakade's attorneys in writing in terms of Section 5.1 of Paja to provide reasons for his recognition decision. And the reference there, no need to go to it, is founding affidavit, paragraph 8, volume 14, page 2689. Those reasons were not provided. And as a result of that, Section 5, subsection 3 of Paja kicked in. And it reads, if an administrator fails to furnish adequate reasons for an administrative action, it must, subject to subsection 4, and in the absence of proof to the contrary, be presumed in any proceedings for judicial review that the administrative action was taken without good reason. So the onus is on the President in this case to show that he acted with good reason. And then before dealing with the relief, 2 points. The one is we simply make this point that there have been intensive debates in the course of the hearing about issues like Ukufakwa, like the interpretation of the letter of the 11th of May, and so on. Those types of issues we submit are not issues that this court has to resolve, including the 14th of May meeting. As long as there's evidence or an allegation contemplated in Section 8.4, that is the issue. That is the determinative decision. And no final decision we would submit is required in respect of those debates. Then an issue that is the implications of which have not been become clear to us yet is that in the Mogale judgment, which declared the Traditional and Khoisan Leadership Act invalid, they suspended the declaration of invalidity for 2 years. That order was made on the 30th of May 2 years ago. So on our estimation, unless the Constitutional Court extends the order of suspension of its suspends its order of invalidity by, we think, midnight tonight, the entire act may become invalid. We have somebody who is involved in that litigation who's reporting to us. They say they still haven't heard from the Constitutional Court. There is an application pending before the Constitutional Court to extend it so that it would remain in place. It's apparently supported by all of the parties and is unopposed, but they do not yet have an answer from the Constitutional Court. But if it lapses, I think it will be necessary for the parties to make written submissions on what the implications of that lapsing would be. And we will keep checking and inform the court if we hear anything. Then, in terms of the relief that we seek, we ask that the President and Prince Misuzulu's appeals be dismissed, with the President to pay Prince Simakade's costs, such costs to include the costs of 3 counsel where employed, and further to include the costs of resisting their applications for leave to appeal. Prince Simakade asks that his cross appeal be upheld with costs, such costs to include the costs of 3 counsel where employed, and to further to include the costs of the application for leave to cross appeal. We ask that the President pays the costs on the basis that this is constitutional litigation and BioWatch therefore applies. There is constitutional court authority directly in point in the Impepo judgment of the Constitutional Court at paragraphs 81 to 83, and there in a similar contest over a leadership position where in fact the President and the Minister abided the decision of the court, so they didn't even participate and oppose or side with any party, they were still required to pay the successful party's costs. So we say we're entitled, in the event of success, to recover costs from the President. We, on the basis of a judgment of this court, it's a majority judgment which was penned by Justice Nichols, if I remember correctly, in South Durban Environmental Alliance, which deals with the costs as between private parties in this type of litigation. And our understanding of that judgment in this case would be that if we were unsuccessful, each of the private parties, as it were, should bear their own costs unless they've litigated irresponsibly. We adopt the attitude that even if we're successful, we only seek costs against the President. We don't seek costs against Prince Misuzulu. One way or another, whatever the outcome, the two are going to have to live together, and we don't think it's going to be helpful to make cost orders. And it's obviously implicit in that we oppose their request for a cost order against Prince Makadi in the event that they are successful. We support paragraph 1 and 3 of the High Court's order. We say that they were correctly decided. Our only gripe with paragraph 2 is insofar as we asked the court to include the word afresh before the word after the word investigation. So we asked them to say investigation afresh. And the purpose of that was to make sure that the President and the investigation panel didn't consider themselves bound by the judgment of Judge Mdondo. And the court did not grant our request. It was contained in a draft order that was handed up and debated in court. And we have included that in we've applied for leave to appeal on that basis and included it in our draft order. And that draft order is to be found at page 4919 of the supplementary bundle. And we there in paragraphs 2.1 to 2.4 have set out what we respectfully submit would be an appropriate order to substitute the order of the High Court. It incorporates the paragraphs that we support, that we defend, but it also adds the word afresh after the word investigation in paragraph 2.3, and it also includes the directions that I explained in argument to ensure that there was an accountable participatory process in relation to the investigation committee. Although we didn't ask for it, it would be within this court's jurisdiction, based on Waterklip and other cases, to also say in this court's order, in the event that we were successful, that the plea of res judicata is dismissed. But the inclusion of the word afresh, I think, would have the same consequence. Those are the submissions. Those are the submissions on behalf of Prince Makadi. Just one remaining aspect, and I have to apologize sincerely to the court in this regard. Our hearing is not great. I'd really struggled to hear from where I was sitting what the dimensions of the application were in relation to the service and the document that was handed up. As I understood it, the President must justify the document that they seek to hand up. and they must do so with an affidavit, and we must answer that. If it's as narrow as that, we don't see a particular difficulty with responding in time if it's essentially legal points that are made in the affidavit. But if it involves us having to consult with Prince Simakade, we have a little bit of a logistical difficulty in that we have an attorney who is in Louis Trichardt, counsel who are spread between Johannesburg and Durban, and Prince Simakade who's in northern KwaZulu-Natal. And I think we would need a little bit more than a day to be able to file an answering affidavit. So it depends really on the ambit of the application that the court envisages.
I just want to go to my notes on the directive